Good afternoon, ladies and gentlemen. Welcome to the 2023 Centre for English Legal History annual lecture. Thank you very much for coming. It's good to have you all here. And good in particular to welcome our annual lecturer this year, Professor Sir Ross Cranston, KC FBA, whose career has spanned academia, politics and government, and the judiciary. Professor Cranston was called to the bar in 1976 and taught first at the University of Warwick and at the Australian National University in Canberra, before appointment as Professor of Banking Law at Queen Mary in 1986. He moved in 1993 from Queen Mary to the LSE as Cassel Professor of Commercial Law, holding that chair until election as MP for Dudley North in 1997, which constituency he represented until 2005, serving between 1998 and 2001 as Solicitor General for England and Wales. He was appointed a Justice of the High Court in the Queen's Bench Division in 2007, and from 2016 was the Judge in charge of the Administrative Court. Retirement from the bench in 2017, followed by a return to LSE as Professor of Law. Professor Cranston has published very widely on a variety of topics, including banking law, consumer law, the welfare state, and law, government, and public policy. His most recent book, Making Commercial Law Through Practice, 1830 to 1970, was published by CUP in 2021. And it's on that topic, the law as Backcloth, Making Commercial Law Through Practice, 1830 to 1970, that Professor Cranston will be speaking to us this afternoon. Professor Cranston.
Well, thank you very much for the invitation to give the lecture. It's not unknown for authors to rewrite passages from their books. It's said that Evelyn Waugh did this with Brideshead Revisited, for example, replacing his original description of Oxford as having the soft vapours of 1,000 years of learning with the soft airs of centuries of youth. You in Cambridge might well think that removing the reference to learning in Oxford was accurate, or more, greater accuracy. This lecture enables me to rewrite, or at least to take further, some of the ideas in my book, Making Commercial Law Through Practice, which Neil kindly mentioned. Although I should warn you that the film is going to be even better. Let me begin with an example from shipping. Not in the book, since the chapter on that subject was jettisoned because of the annoying habit of publishers, to authors anyway, of imposing word limits. Here's the renowned Thomas Edward Scrutton, a great figure in English commercial law, and the subject of an excellent biography by the judge currently in charge of the Commercial Court in London, Miss Justice Foxton. Scrutton was a product of this institution, or at least Trinity, a leading King's Counsel at the time of this quotation, and later a High Court judge and Court of Appeal judge. A difficult figure, to put it no higher, and perhaps an overrated one. There's a passage in the first entry in the DNB, now excised. "I remember Scrutton," said the Nobel laureate in physics, Sir Joseph Thomson, shortly after Scrutton's death, "a very clever man of immense industry, but no originality." Well, Scrutton's reputation as an outstanding commercial law was sealed with an embarrassing encomium by Professor Carl Llewellyn, the main author of the Uniform Commercial Code in the United States. In the opening sentences of an article in the 1936 Columbia Law Review, Llewellyn wrote, quote, "I've never sent a student to the opinions of Thomas Edward Scrutton who did not come back bubbling and dreaming of a trip to England. And to that man, I too have dreamed that dream and planned that trip. The man, Scrutton himself, was oak. And so it goes on, but I'll spare your blushes. David Foxton tells me that there's no evidence that Llewellyn ever made the trip, although, of course, the world was a larger place in those days. Well, back to this quotation, and the background was the tension between the ship owners and the dock owners over their respective liabilities for lost or damaged cargo when the goods got to the port, the docks. Under the so-called North American clause, which shipping businesses like P&O inserted in their standard form bills of lading, they weren't liable once goods were free from the ship's tackle. Before this Royal Commission, which was considering the future of the London docks, and whose findings eventually led to the Port of London Authority being established in 1909 by legislation, still exists, of course, Scrutton was cross-examining the chair of the London and India Docks Company, J.C. Scott. He inquired about the North American clause. And you'll see there, Scott says, it's never used here. And P&O will tell you that. Scrutton doesn't accept it. He's cross-examining Scott. Scrutton, briefed by the ship owners. He points to the words, the clause. Scott's adamant and explains the reason why the contractual wording is ignored. If they're free from responsibility as soon as the goods leave the ship's tackle, how does it come to pass that they truck these over the quay and then deliver to the craft from the quay? There's a great deal more than the ship's tackles, and that is why I say that this clause, so far as P&O is concerned, is entirely inoperative. Well, I'll return to the import of that quotation, the disjuncture between law and practice, and how practical merchants regarded the law in a little while. But first, some context. The subject, my subject is a broad one, law's role in Britain's international trade and manufacturing, and the financing of these from about 1830 until the beginning of what might be regarded as the modern period of international trade and finance, the 1960s and 70s. Britain, of course, was the first industrial nation, an international power, extensive empire. It had huge international trade, admittedly after the two world wars very much disrupted and bounded. And, of course, technical changes, containerization. At one point, London was said to be the largest port in the world, importing and exporting goods for Britain, but also acting as an entrepot for other parts of Europe, and later a centre organising trade elsewhere. Now, I can't ignore Liverpool, which had a very large trade, and I've got quite a lot of that in the cotton trade in the book, and there were other important ports like Southampton and Hull. In London, there were extensive docks to deal with this trade, like the London and India docks referred to in the quotation, which became part of the Port of London Authority. This is just part of this extensive docks. And you can see there part of the West India docks and also part of the, I think that's part of the London docks as well. So the docks so in addition to the docks, there were the wharves along the private wharves along the river. You may have eaten in some of these converted London docks, Butler's Wharf, for example, what's now called Hayes Galleria, although perhaps these days you haven't eaten there, given the price inflation I find in London restaurants. So these docks and these wharves handled huge imports, the raw materials for manufacturing, food for the new middle classes, the workers in the factories, the service industries, timber, commercial docks on the other side of the river, huge timber imports. There were also manufactured goods for export. Until the middle of the 19th century, textiles had been the dominant export, but after that, machinery and other capital goods became significant in the Britain's total exports. And here we've got a photograph of steam engines being exported. These were steam engines manufactured by the firm Stephenson and Hawthorne's. Stephenson was the first builder of the rocket, which was the first steam engine to carry passengers in 1825 on the Stockton to Darlington Railway. The quotation, of course, is this is the valet to Phileas Fogg. He's in India, and there he finds everything British: the engines, the engine driver, the coal, and so on. Of course, Britain's dominance in manufacturing was gradually forfeited in the years prior to the First World War with the growth of Germany and the United States, and was in relative decline after that. Now, associated with this trade were a number of institutional developments relevant to the commercial law story. First was the emergence of organized markets and the trade associations, which had the mission of bringing order to those markets through establishing standards, laying down rules and regulations, drafting standard form contracts to govern individual transactions. Next, the trade demanded a network of agency and other distributional arrangements, and in fact there were the great agency houses established by British interests abroad in India and Hong Kong and so on. Then there was financial backing needed to finance these, the export and import, and that was furnished by a very sophisticated system of trade finance based on bills of exchange and letters of credit, organized by the great merchant banks, the Rothschilds and the Barings, and later by the joint stock banks such as Midland, which got into this. Further, there were institutions like the London auction houses setting world prices for commodities. There were the clearing houses for payments and futures transactions. There was the London money market, centered on the Bank of England, and the discount houses, and of course sterling was the world's reserve currency. Then there were the shipping markets, based in the Baltic Exchange, arranging the hire and sale of ships. Then, of course, the insurance market based around Lloyd's. So by the end of the 19th century, Britain was the world leader in many of these, with the added advantage, as the economic historians have written, that they were clustered in the City of London, so that the trading, the financial, insurance, and shipping interests were greater as a whole than as individual institutions. Now, all this, as I mentioned at the outset, had a dark underbelly, exploitative, racist. It was a world of empire, and for the most part, a world of men. Law sometimes ameliorated these tendencies, but also, in some cases, reinforced them. I'm not going to address these issues, but there's no way, getting away from the fact that the Liverpool cotton trade was based on slavery, and these great agency houses I mentioned were closely involved in the Chinese opium business. And then, of course, there was the treatment of labour in the textile mills and manufacturing industries and abroad in Britain's estates and factories. Now, my question is the role of commercial law and lawyers in this, in these markets, in this trading, in this manufacturing, in this distribution, in these financial arrangements that I've briefly outlined. So let me advance three models of this relationship. The first is what I'd term the conventional model, and it's taken various forms over the years, but in broad outline, it's that Lord Mansfield set English commercial law on its feet when he was Lord Chief Justice of the King's Bench in the late 18th century, and it continued on that basis. So Sir Frederick Pollock put it this way. Just before the First World War, he published a multi-volume series, The Commercial Laws of the World. And in the British volume, Lord Mansfield's there, he's responsible for, quote, a scientific system which preserved the original vitality of the material derived from custom, end of quote. There's mention, of course, of Mansfield's famous method of seeking the assistance of commercial jurors, and Pollock, interestingly, says that this cooperation between a good judge with a good mercantile jury was by no means extinct, although it was better seen, he said, in Liverpool or Manchester than London. Now, as to the substantive law, Pollock continued, apart from the statute of frauds, our law of sale, let's see if I've got this, oh yes, our law of sale, notice actually Scrutton is there as the consulting editor. Our law of sale has developed in the course of the 19th century on strictly scientific lines. Evidence of commercial custom, a usage, of course, as the alternative, the more technical phrase, in particular kinds of business, not as universal custom, but as a tacit convention between the parties, has been rather freely admitted. Now, as editor of the official law reports and also of the Law Quarterly Review, Pollock was an authoritative voice. As Professor Brian Simpson described him, one of the shoals of Pollock's in the law in the 19th and early 20th century. Quite a number of Pollocks around. Pollock's view of the substantive law was mirrored in the Encyclopedic Compendium of Mercantile Law, published first by a barrister called Smith in 1834. That book ran to 13 editions, the last, incidentally, by Harold Guttridge, who was Cassel Professor. Neil mentioned that I occupied the chair at one point, but Guttridge was a Cassel Professor at the LSE until he was lured here to the dampness of the Fens. In the first edition, Smith had suggested in his preface that unlike real property law, whose doctrines were historically conditioned, quote, the mercantile law is deduced from considerations of utility, the force of which the mind perceives as soon as they are pointed out to it, end of quote. So in this conventional model of commercial law history, the judges are the drivers of the process, the practitioners are the journeymen. Lord Wright, who was a great figure in commercial law in the 1920s and 30s and into the 1940s, gave a lecture to the University of London Law Society in 1937, and he said this: a constant process of innovation and amelioration is being carried on by the judges, as it has been through the long history of commercial law, with the help of practitioners. Now, as I say, he was Dr. Robert Stevens, the late Dr. Robert Stevens, in his history of the House of Lords, says of Wright that he was one of the few significant British appeal judges of the 20th century. I'd add, because of the LSE connection, that when he started at the bar, he was also teaching industrial law part-time at the LSE to make ends meet. And he continued actually from about 1897 to about 1915, I think. 2 years prior to this University of London lecture, Wright had, let me put him up there, Wright had given his Holdsworth Club lecture. It had the tantalizing title, Some Developments of Commercial Law in the Present Century, and there Wright gave an account of some developments of commercial law in the 20th century. But in one of the few passages when he ventured beyond the mundane, Wright commented on the use of standard form contracts. With the old types of commercial contracts, such as bills of exchange, he said, the contractual documents were bare and meagre, but there has grown up around them a great mass of detailed and complex rules. Now, as to contracts of sale, you'll see there, he said that contracts of the sale of goods often provide for matters of detail, but in all cases only with more or less completeness, so that the courts could not decide disputes without supplementing the express terms. It's that process that's created commercial law. So that's the sort of conventional view, and I'll come back to it. There's another possibility, which is a dialectic exchange model. And that comes from adopting a model which legal historians have ventured for related areas like corporate activity rather than the transactional approach that I'm taking. It's the view advanced in the seminal study by Professor Costello, Law and English Railway Capitalism. And in that analysis, the English common law and common lawyers had a profound, but in his view, largely negative impact on the rise and development of railways. Railways and the railway enterprises were captured by law, legal ideas and processes, and they had a huge capacity to generate legal work, conflict and opportunity. This manifested itself in the lawyers becoming heavily involved in the promotion and demise of railway companies, sometimes sham bubble lawyering, as Costello calls it, extensive litigation, as with the railway companies' successful grab for the carriage of small parcels, their resistance to local government taxation in the claims against them for personal injury compensation. In his account, the large railway companies had in-house lawyers, and the railway industry's most crucial conflicts were decided by judges and juries. So there's a second possible model. A third possible model is what I'd call the legal boosterism model. And this is a very much contemporary account of what lawyers do these days with commercial transactions. Although I should say there's some evidence in the case law where you see judges saying that, particularly in the first part of the 20th century, judges proclaim that their decisions are conducive to, for example, what goes on in the City of London. Well, this legal boosterism model is very evident in contemporary accounts. There are reports such as that by Legal UK, which was established in 2017. In this report in 2021, we see that there's a focus on the economic value of English law and English lawyers, specifically as it relates to business commercial transactions. The English lawyering brings to the UK hundreds of trillions of pounds of business activity. The report itself states that English law is a key part of what makes the UK an attractive path to do business. for internationally mobile activity. And one of the remarkable facets of English law is the extent to which it's the international standard for contracts in many internationally mobile markets. And of course, in this account, English lawyers are there at the centre, even if employed by the large American firms, which are now very prominent with in their London offices. And there are various other reports as well, which effectively replicate this approach. And I've got there Liz Gloucester, a former colleague who is now very prominent in Legal UK. So, in summary, we have three possible models. The conventional model, with the substantive law derived in important respects from commercial custom. Judges are in the vanguard, lawyers hardly in evidence, supportive role, said Lord Wright. The judge is said to be spending time filling in the gaps in standard form contracts. Then you've got the dialectical exchange model. There, English common law and lawyers are playing a crucial, but in some significant respects, negative role in commercial development. This dialectic spawning extensive litigation and witnessing the appointment of in-house counsel in large organisations. And then we have the legal visitorism model, in which practicing lawyers are centre stage. They're critical to the commercial and financial ecosystem. English commercial law substantive commercial law is crucial in some undefined way as to its substance, but it's crucial to economic success. The law is there to resolve disputes. The courts are there to resolve disputes. And it seems that the conception is that the law, that the courts are applying rather than making commercial law. Now, given what I said earlier, where I began with Scruton and the North American clause in standard form bills of lading, it won't surprise you to learn that, in my view, none of these models fully reflects the reality of law's role in commercial and financial transactions during my period. Note that my subject matter is transactions. It's not institutions like the company, as in Professor Costel's case and other authors' case. It's not corporate law, it's transactional law. And that may explain a difference in the analysis. Pardon me. There may also be a difference of sources. I used business archives to focus on the internal view and the internal doings, rather than focusing on what the trade or the professional press were saying. But what's my take then on the reality of law's role in commercial and financial transactions during the period I'm covering? Well, here are some highlights, which I'll place under three headings. Firstly, and the three headings are these: substantive law in the courts, private lawmaking, and the subordinate role of lawyers. So first of all, substantive law and the courts. In summary, commercial custom was taken on board by the courts during my period. And the judges did drive doctrinal changes beneficial to commerce, but there were important wrinkles. As regards commercial practice, judges were not in the vanguard, nor was there much in the way of a dialectic exchange. many a commercial practice remained untouched by the courts. If it was often well after the practice had become entrenched, and what the judges were doing was to place their seal of approval on what had been, or what was being done. So that's a summary of the substantive law and the courts as I see it. Now let me spell some of these points out a little further. Custom and practice, commercial custom and practice, as suggested in the conventional model, trade usage, to use that precise term, could have normative force. Whether it did depended on whether the practice was so widely observed and so well known in a market or locality that it was taken as the basis of contracting. Until the First World War, when civil juries faded, the existence of trade custom might be decided, as Pollock suggested in the piece referred to earlier, by juries. Once the existence of a commercial custom was established, the courts used it in two main ways. First, to decide whether the words of a contract were subject to any peculiarity of meaning in a trade or area, and secondly, to imply terms upon the presumption that the parties had contracted with reference to the commercial custom. Now, apart from the commercial customs in specific trades and operating in specific areas, in particular ports, there are a lot of cases about customs in ports. There was the occasional great case like Goodwin and Roberts in the 1870s, early 1870s, which extended negotiability to bonds being sold on the international market. In that case, they were bonds issued by the Rothschilds on behalf of the Russian and the Austro-Hungarian governments. Very important case in terms of commercial custom. So, commercial custom was important. Some caveats. First of all, it had little scope in the case of transactions where there were standard form contracts. And as I've indicated, standard form contracts are important especially in export and import, international trade, and in other transactions like shipping. But there was a long-established rule that commercial custom couldn't be invoked to contradict the terms of a written contract. So that was one limitation on custom. The second limitation was that towards the end of the 19th century, the mood turned against commercial custom as a source of law. It was more an age of legal formalism, and that tended to stifle the extent to which custom was used. There was also criticism as well that the courts were accepting commercial custom too readily. They were too fast and loose in accepting custom and using that as a basis for law. So there was custom. In addition, there was the facilitative role which the courts played in commercial arrangements. Of course, they decided who had won, or at least who had won the current round, since litigation was often part of an ongoing campaign. But they also laid down rules for future transactions in markets and for services like banking. And in doing this, the courts were often attempting to use Smith's phrase in this compendium of mercantile law to work from considerations of utility, or as I put it, acting as a dispute resolution forum accommodative to commercial practice. Now, there are a number of areas where one can trace this through the doctrine. Agents and agency was one area where the courts developed a number of doctrines which were facilitative to the work of agents as institutions. So too in sales. It wasn't on strictly scientific lines as Pollock described it, but it was facilitative of commercial transactions. In the early 19th century, which was still an era where moral sentiments held sway, the judges had recognized the implied terms in contracts of sale, and they became a cardinal feature of the law and also of our language. We hear on the radio constantly that things are not being fit for purpose. Well, a phrase taken from the law of sales, not being merchantable. The latter implied term was graphically expressed by Lord Ellenborough in his famous dictum, "The purchaser cannot be supposed to buy goods to lay them on a dunghill." Well, those implied terms survived attempts at sabotage by judges infected with the ideas of the new political economy, and they were codified at the end of the century by Mackenzie Chalmers in the Sale of Goods Act of 1893. But we'll see that they were often modified, as the law allowed them to be, in their practical import. Now, law incorporating commercial custom, law facilitative in terms of doctrinal developments, but not always. There were wrinkles where judges refused to accommodate to commercial practice. To give just one example, there's the case of, wait a minute, where are we? Well, I passed over that. That's the advertisement for the book, which I shouldn't have passed over, but it explains the commercial custom. I was asleep, as it were, at the button. But anyhow, we've moved on. We've now got the wrinkles. There's this case of Cook and Eshelby, and a very important case in the operation of markets. It was actually about the Liverpool cotton market, and it concerned this doctrine of undisclosed principle, a peculiar doctrine of the common law, whereby if the parties weren't dealing with each other as principals, an undisclosed principle could suddenly appear as a person to the deal. And in the evidence which was given in the case, the members of the Liverpool cotton market said, look, we can't operate with this doctrine of undisclosed principle. If I deal, as one of them said, if I deal with a broker, I treat that broker as the dealer. I don't know anybody else in the transaction. If an undisclosed principle comes forward and claims on a certain portion of the contracts, those are in his favour and saddles me with the rest, my position is entirely altered. So they didn't like this doctrine of undisclosed principle. Well, you'll see here the House of Lords was unsympathetic, and I quote one of the members of the House of Lords who says, we can't alter the law to suit the views of or the convenience of the Liverpool cotton market. So you had a number of situations where, although generally accommodative, the courts did stand their ground, as it were, and said we can't alter the common law to suit particular commercial practices. And you got that as well with in other transactions, which I don't have time to go into. But look what the brokers, the members of the Liverpool Cotton Exchange, did. And it was explained by this cotton broker, C.W. Smith, some years afterwards. There was this case, he said. I took it to the association. I told them we couldn't live with it. No man would dare to trade under those systems. In the full quotation, he says, we formed a committee and we introduced a new contract. Actually, they introduced a new clause into the contract which said we don't recognise the adoption of undisclosed principle. In other words, if you deal on our market, you're dealing as a principal. So that no undisclosed principal can pop up and assume the contract. So there, the flexibility of the law was such that, and I'll come to this in a moment, the expectation of dealings which had existed hitherto were able to continue by changing the standard form contract. Now, I said earlier that sometimes the courts were, I said generally the courts weren't in the vanguard, and sometimes they would come along and they would give their imprimatur to a commercial practice after it was well established. And there are a number of examples of this, quite a number actually. So, for example, with hire purchase, which is now asset leasing, it became well established towards from the middle of the century. We tend to think of hire purchase these days, if we think of it at all, as a retail marketing tool. In fact, it was very important commercially in the 19th century, and still is under the flag of asset leasing. You lease the aircraft, you lease machines like this, and so on. You lease vehicles. Well, that practice had developed. There was then a case where it was where the way that people accepted it was being done in the market was suddenly questioned by a lawyer who took a case on behalf of someone who had entered into a hire purchase transaction. So the association took a test case, it went to the House of Lords, and in the great case of Elby and Matthews, the House of Lords said the lower courts are wrong, and we're going to recognise, effectively, we're going to recognise hire purchase as a separate technique from sale. It's not sale, it's something quite separate. And you see other examples as well, where the courts, there was a well-established commercial practice, challenged at a particular point, and the courts then said, we're going to approve the way things are done. And often, contrary to doctrine or ignoring doctrine. Letters of credit, I said, very important in financing international trade. Big issue of doctrine, where's consideration? No consideration with a documentary credit. Well, the courts said, well, notwithstanding that, we're going to recognise the force of letters of credit, and they did that in other areas as well. Bank overdrafts, payment on demand, the bank can get back its money straight away, well, we're going to recognise that, and so on. So, notwithstanding any doctrines to the contrary, the courts would come along and give their imprimatur. Professor Roy Good has got a colourful phrase about this when he's talking about one particular aspect, but it can be generalised. He said, the power of the market to pull itself up by its own bootstraps. And there's the pressure of the courts to avoid decisions that are going to threaten a whole orderly continuance of a practice. So that's substantive law and the courts. Another area is private lawmaking. There was an enormous amount of private lawmaking. I've said standard form contracts. The trades developed their standard form contracts. And as I said earlier, they were able to vary the common law. Institutional rules, I mentioned the Baltic Exchange, the great market for grain and shipping still exists for the chartering and buying of ships. There was what is now the London Clearing House, which provides clearing houses for customers across continents. and that was developed by the proponents of the clearinghouse drawing up the rules. Trade association rules. There were cases where motor vehicles became a mass purchase, and the manufacturers wanted to control how they were distributed, retail price maintenance, and so on. Again, the trade drew up rules, and the courts upheld these. So it's Lord Wright's story of the courts filling in gaps is partial at best. The reality is a much more interesting story of contracts being drawn by commercial parties, lawyers being involved in their making to some extent, and the contractual terms mandating arbitration often, so as to minimize the intrusion by the courts. So it's not state law, it's private law making. There are a number of examples which I will pass over in the interest of time, but I've mentioned standard form contract in sales, in these international commodity sales, but the trade changed the common law, and it wasn't that the goods were fit for the purpose or merchantable. The trade didn't rely on that. Say for example, with the sale of the railway engines. You couldn't rely on a general provision for fitness for purpose or merchantability. You had to have something much more detailed. So there were detailed specifications for the manufacture of the engines. Then there were provisions in the contract whereby the buyers would appoint agents, engineers, who would come and inspect the process, inspect the manufacturing process. And then there was an after-sales service as well. So quite different from what the common law contemplated, a much more sophisticated system. Now, as I say, my interpretation of events is that law's role in this private lawmaking was not gap-filling, as Lord Wright said, but the law provided a number of advantages. The courts offered overarching principles, often not articulated in the cases, but there nonetheless. And of course, freedom of contract was most important if you're going to be able to adapt and, in some cases, reject the common law principles. Of course, the freedom of contract, a fundamental doctrine from the 19th century that, as was put in one account, an adamantine a degree of hardness in contract is no ground for relief. People kept to their bargain. Lord Bramwell's view had much support, even if it was only at an unconscious level. The consequences of freedom of contract, like market speculation, may be thought distasteful, he said. But in one case, he went on to say that we now have so many railways and other useful undertakings is a result of freedom of contract. The point about it was that it enabled private law making. The second overarching principle was certainty. And that was expressed by Lord Mansfield in a case in 1774. He said that bright line rules were there. It meant that traders, merchants, brokers, and bankers know what ground to go upon. In other words, they could readily understand the principles. Finally, the third point I would draw on is the subordinate role of lawyers in my account. It certainly is not the boosterism model where the lawyers are there and everywhere. Things have moved on. Until the 20th century, in transactional commercial law, lawyers were not regularly engaged in the work of formulating rules and contracts. Even in advising trade associations as to how disputes were to be settled. Once you got beyond the arbitration, yes, but in the commodity markets, lawyers were kept out. You weren't allowed to be involved in arbitration. The arbitrations were conducted by the trade itself. For much of our period, lawyers' involvement was more with drafting the requisite documents to carry on business rather than with the standard form contracts governing how transactions were to be conducted and dealings cleared. As I've said before, the drafting of standard form contracts was a practical exercise undertaken in the main by the members of the trade themselves. They knew the trade, the purpose behind the clause, the result they wanted to achieve. The trade associations, outside solicitor might be involved, occasionally counsel, but that was generally reserved to when there was a tricky issue. So lawyers are on tap and not on top. It's only in the 20th century that we see solicitors much more involved in advising on standard form contract drafting. And of course, by then, there were more disputes that had gone from the arbitrators up to the court. But as I've said, it was a world of practical men. They knew what they wanted. They're generally confident that they can express this in their contracts. Although they, as I say, with time, they're aware that as their clauses become more complicated and the case law builds up, legal advice is going to be needed. In terms of manufacturing goods, it seems that when you started to get manufacturers, vehicle manufacturers in the 20th century, for example, you did get more the appointment of in-house counsel, which is the point that was made in relation to the railways. The larger organisations, you tended to have more an in-house solicitor. I discovered the other day that an LSE, a woman who had attended the LSE, one of the first women lawyers, later went into John Lewis and worked as the in-house lawyer there. She moved there in 1932. So that was an increasing tendency. Let me draw it to a close. In fact, where are we? If the three models that I sketched earlier aren't a good fit for the development of commercial law from the early 19th century to the beginning of the contemporary period, how do you best characterize it? What is the best, which is the model fit for purpose, to use that phrase? In other words, how would I characterize my approach? Which I didn't do in the book. At one point, I toyed with the metaphor of a backdrop. A backdrop in the theatre, of course, referring to the back of the stage or the setting for the scene, but of course now used more widely. In my account of commercial law over the period, formal law could be said to have furnished a backdrop for commercial and financial activity, with party autonomy empowering commercial parties to engage in private lawmaking, designing the market rules, standard form contracts and the institutions they fancied. Lawyers and courts are kept at bay, with disputes being resolved informally or dealt with through private dispute settlement in the form of arbitration. Whether law, as I didn't, as I say, adopt that in the book, but whether law as backdrop is a right way to characterize what I found is very much for you to judge. Thank you very much for attending.